Welcome back to the deep dive. For centuries, philosophers, lawyers, and, well, politicians have all grappled with the same agonizing question.
Right. How do we establish human rights as truly universal?
Exactly. Not just as a good idea, but as necessary, non-negotiable. We've tried grounding them in God, in nature, in some kind of shared moral feeling.
And every time those foundations wobble, they bump up against different cultures, different political ideologies, different religious beliefs.
And then the whole structure feels like it could come crashing down.
That instability is the central problem we're tackling today. Because if human rights are just a set of preferences, even, globally accepted preferences, they can always be debated away.
They become optional.
They become optional. So today we're diving into a radical, and I have to say an incredibly sophisticated philosophical answer. What if the ultimate defense of human rights has absolutely nothing to do with morality or religion or even feeling, but simply with logic?
Now, that's the core promise of our source material. We're going to explore an approach that's rooted in the phenomenological tradition of Edmund Husserl and Adolf Reinach.
And the idea at its heart is this: to deny a basic human right isn't a moral failing. It's an act of pure legal incoherence.
So it's like a logical contradiction.
It's the legal equivalent of saying that 2 + 2 = 5. It just doesn't compute.
Our mission today, then, is to show you how this argument is built, how it proposes that human rights are not prescriptions for behavior.
They're not telling you what you ought to do.
Right. They are a purely objective description of what law must be in its most fundamental essence.
We call this the material a priori essence of civil law. It's a bit of a mouthful, but we'll break it down.
And to get there, we'll need to navigate some fascinating and admittedly tricky philosophical terrain. We'll be introducing concepts like epiche, eidetic reduction,
And the difference between necessary relations and necessary content. Formal versus material a priori.
But the goal is to give you a shortcut, to not just know what human rights are, but to understand the deep logical structure that, according to this theory, makes them absolutely indispensable. So let's unpack this. All right. To understand how we can even begin to describe the universal essence of law, we have to start by learning how to look at the world differently.
Right. We have to reset our perspective.
And this begins with the method developed by Edmund Husserl, which requires us to overcome what he called the natural attitude.
The natural attitude is our default setting. It's how we navigate the world, and it's inherently biased. We use it every single day.
Can you give us an example?
Sure. When you see a chair, you don't really analyze its specific color or its molecular structure. You immediately categorize it based on your preconception thing to sit on.
I don't even think about it. It just happens.
It's automatic. This attitude is built on a massive accumulation of unreflected judgments and convictions about the world. It's incredibly useful for survival.
But not for philosophy.
Utterly useless for philosophy.
Well,
Because it presupposes the very things we need to investigate. It takes the world for granted.
okay, so if the goal is to see the object of our study, in this case law, without any preconceptions at all, how does Husserl propose we achieve that kind of philosophical clarity?
He introduces the first critical step, the epiche.
The epiche.
It's sometimes translated as suspension or bracketing.
I like bracketing. It feels like you're putting something aside.
That's a great way to think of it. Imagine you're putting the world in parentheses. The epiche is this conscious, deliberate attempt to suspend all universal judgments, all your convictions, all your preconceptions.
So wait, I'm not denying that the physical world exists or that the laws of physics are real?
No, not at all.
Or even my own moral beliefs. I'm just refusing to use them as criteria for judgment in this moment.
Exactly. You are suspending the belief in the reality of the world as you conventionally understand it. You're trying to achieve a state of pure freedom from conviction, from expectation, from supposition.
So the knowing subject, me, I just look at the object purely as it appears, as it shows itself.
Yes, with the sole intention of unveiling its objective content, its noema, as he called it. This process allows the object's essential structure, which was previously obscured by all our everyday assumptions, to finally come into focus.
Okay, so once we've successfully bracketed the world, performed the epiche, the next step is to move from that specific appearance to the necessary universal structure.
Right.
This is the eidetic reduction. How does this reduction uncover the essence of a thing?
So the eidetic reduction logically follows from the epiche. It's based on what Husserl called eidetic intuition, which is that moment the subject directly apprehends or grasps the object's essence.
An aha
Moment.
kind of. But intuition alone isn't enough. We need a formal method to describe this essence we've intuited. And that's where mental variation comes in.
Right, the thought experiment. Walk us through that variation process again, maybe with a simple example, to show how it reveals what's necessary versus what's just accidental. Okay, let's stick with the legal concept. Imagine you are focused intentionally on the concept of a contract.
Okay.
You start mentally varying its characteristics.
Yeah.
What if the people involved didn't sign anything?
Well, it could still be a contract, just an oral one.
Exactly. So that characteristic, a written signature, is accidental. Now, what if the people involved were only thinking about the terms privately and never actually communicated them to each other?
Then it's not a contract, it's just a wish or a plan.
Right. It stops being a contract. Or what if the contract involved only one person? Say, I make a contract with myself to pay myself $100.
That's absurd. That's not a contract. It's just a mental note, a unilateral resolution.
Precisely. So the characteristic of requiring at least two communicating subjects is essential. If you remove it, the contract, ceases to be what it is and becomes something else entirely.
So that non-variable necessary core that remains after you've done all this mental variation, that's the essence.
That is the essence, or the eidos, as Husserl called it. And this eidos is necessary and universal. It doesn't matter if we're in ancient Rome or 21st century New York. The eidos of a contract remains the same.
And this universal necessary structure is what Husserl defines as a priori.
Yes, that's the key.
This seems to require us to clarify how consciousness itself works in this method. Husserl viewed it as having these two inseparable dimensions, right? The subjective act and the objective content.
He did. And it's important to get this relationship clear.
Can you simplify the relationship between noesis and noema for us?
Certainly. The subjective dimension is the act of consciousness itself. The thinking, the judging, the remembering. This is the noesis.
My act of thinking.
Right. And the objective dimension is the content of that act, the object that is perceived or remembered or judged. This content is the noema. So when you think of a red cube, the noesis is your act of thinking.
And the noema is the concept of the red cube itself.
Exactly. And the phenomenological method focuses squarely on the noema, because the noema contains both the accidental characteristics, like the specific shade of red on the cube, or its size, and the essential characteristics.
The eidos.
The eidos, the necessary three-dimensionality in form of cubeness. The goal of the eidetic reduction is to strip away all those accidental elements and isolate the necessary noematic structure. This structure is universal, and it plays an essential role in how we perceive and understand the object.
Okay, this leads us to a really crucial commitment in this whole theory, the realist interpretation. We have to be absolutely certain that this method is accessing the essence of the object itself,
Right.
not just the essence of how it appears to us in our minds. Why is it so important that we commit to realism here?
Because if phenomenology only described the essence of the phenomenon, how law appears inside my head, the whole foundation would still be subjective, conditional. It wouldn't be universal.
We'd be right back where we started.
We would. But the phenomenological method, as interpreted by realist commentators, is not representationalist. It asserts direct intuition of the object's essence.
That's a huge distinction. It means the necessity, the a priori structure, is in the thing.
It is. It's in the world. By accessing the eidetic universality that is manifested in the empirical object, phenomenology moves beyond just being a study of appearances.
It becomes a science.
It becomes an eidetic science, or an ontology, a description of the necessary and universal being of things. And this gives us the rigor and the objectivity we need to ground law universally. Because the structure of our consciousness, noesis, and the structure of the object, noema, are seen as essentially linked, granting us direct access to the necessary essence of the object out there in the world.
So we have this robust philosophical tool, the phenomenological method, that can, in theory, reveal the necessary universal essence of objects.
A very powerful tool.
Now we apply it to law, specifically to civil law, through the work of a key figure named Adolf Reinach.
Right. Reinach was an early figure in the phenomenological movement, and he decided to apply this new science of essence to the social realm.
Which is a much messier place than, say, geometry.
Much messier. He quickly realized that the traditional categories, physical objects, psychological states, timeless mathematical ideals, they didn't quite capture things like promising or forgiving or commanding.
Things people do to each other.
Exactly. So he introduced a new category of existence: social acts.
What makes a social act so unique that it needs its own ontological category? Why can't we just call it a behavior?
Because they are, as he put it, temporal objects of a special kind.
Yeah.
They occur in time, yes, but they aren't just physical movements like waving your hand.
Nor are they purely internal, like feeling sad.
Precisely. Reinach spent a lot of time distinguishing different types of acts. You have, passive acts like listening, and then spontaneous acts like feeling joy or sorrow. Those are internal, they're uncontrolled. The subject isn't the rational author of them.
But the ones that are relevant to law are the active acts.
The active acts, these arise from a conscious decision or resolution. They are free and motivated. Promising is the perfect example.
Okay, so what are the key requirements for something to be a social act?
Crucially, there are three. First, they must be manifested externally. Spoken, written, signaled in some way.
Can't just be in your head.
No. Second, they must be perceived as such by others. And third, they must presuppose a second subject at whom the act is aimed.
So the very definition of a social act requires intersubjectivity. I can't command if there's no one to command. I can't promise if there's no one to promise to.
Exactly. And law, which is defined as official enactments, is a content of social acts. It requires a legislator, the source, and citizens, the aim.
And this immediately tells us something profound about the essence of law.
It does. There can be no civil law for a hermit alone on an island. The very structure of law is inherently relational.
So Reinach's overall goal here was to conduct an eidetic investigation of civil law and ontology of law.
Yes, to reach its necessary universal essence, which he called its a priori laws.
He was hunting for the structural constants of law, the deep grammar.
That's it. And it's crucial, again, to stress that this is completely distinct from positive law.
The laws on the books.
Right. Positive laws are contingent. They are the specific statutes, contracts, and court decisions that vary widely by jurisdiction and change over time. Reinach was not concerned with whether a law was effective or fair.
He was focused purely on the ontological region of law.
The structure that makes civil law possible and comprehensible in the first place.
And his most successful and I think most famous demonstration was his description of the formal a priori law of civil relations.
Yes.
Let's really sink our teeth into his key example here, the relationship between promise, obligation, and claim.
This is a beautiful piece of phenomenology in action. Reinach argued that the necessary universal relation between promise, obligation, and claim exists as an ontological truth. It's real, and it's independent of any statute book.
So if I, as a rational, free being, make a promise to you,
You necessarily incur an obligation, and I, the recipient of the promise, necessarily acquire a corresponding claim against you.
it's not just a societal convention that we should feel obliged. The obligation is inherently generated by the act of promising itself.
That's the key. It is a necessary relation. Imagine a legislature passed a law tomorrow stating, all promises made after January 1st create zero obligation and zero claim.
You could enforce that, I suppose.
You could enforce it as positive law, sure, but that law would be structurally inconsistent with the essence of what a promise is. The positive law would be denying an ontological fact about the social world. It would be, as you said earlier, like legislating that 2 + 2 = 5.
A successful failure, if you will.
A successful failure. That's a good term for it.
So this formal a priori describes the necessary relational plumbing of law, the system of connections.
Yes, and Reinach believed this formal truth applied universally across legal, moral, and cultural spheres. He demonstrated that necessary relations, grounded in essence, actually exist in the legal world.
It was a monumental achievement. He showed we can access necessary truth in the social world.
He did. However, as we're about to see, he described the relations of law, but he didn't quite get to the necessary content of law itself, and that's a crucial gap.
Okay, so we've established that the phenomenological method can find these necessary universal structures, the a priori. But before we use this to ground human rights, we need to clarify two really crucial philosophical distinctions.
Right. These are important to avoid confusion.
First, how does this phenomenological a priori differ from, say, the more famous Kantian a priori?
This is critical to avoid making philosophical category errors. The phenomenological a priori is transcendent.
Meaning what, exactly?
It means the universal essence is located in the surrounding world. It's accessible through intuition, and it's manifested in the eidetic dimension of the object itself. It exists outside of me.
Okay, unlike the Kantian version, which is transcendental.
Precisely. The Kantian a priori is located in reason, in the mind, in consciousness. It's the filter or the structure that our minds impose on the world to make sense of it.
the organizing principles of the mind.
Yes. But phenomenology rejects this idea of imposition. It maintains that commitment to realism we talked about. The necessary essences exist independently of our consciousness, and our consciousness simply accesses and evidences them directly. The universality is in the world, waiting to be described.
That clarifies the location of the necessity. Now for the second, and arguably the most important distinction for our whole deep dive today, the separation between formal a priori and material a priori.
This is the move that opens the door to finding human rights. Reinach used the term a priori a bit loosely, applying it mostly to these necessary relations. But to truly understand the essence of law, we need to distinguish between its structure and its necessary content.
Give us a clear analogy for the listener. How can we visualize this difference?
Let's think of building a house. The formal a priori would be the necessary relations, things like architectural geometry, the necessary connections between the plumbing pipes, the structural load-bearing principles. It dictates that if A happens, B must follow.
Like if water enters the intake pipe, it must exit the drainage pipe. That's a necessary relational truth of that system.
Exactly. Reinach described this relational geometry. A promise necessarily leads to a claim.
Okay, so that's the formal part, the structure. What is the material a priori?
The material a priori is the essence or necessary content, the eidos of the thing itself. In our house analogy, this would be the necessary content that defines the house as a house, rather than a bunker or a ship.
So things like shelter, security, a certain human scale.
Right, the stuff that makes it what it is. For law, the material a priori is the essential content that, if you take it away, means civil law stops being law at all.
And this is where we can really pinpoint the gap in Reinach's original analysis. He perfectly described the plumbing, the formal a priori.
The necessary relations like promise and claim.
But he didn't fully describe the necessary content flowing through those pipes.
Correct. Reinach gave us the formal a priori of civil law, the universal and necessary relational dimension. But he didn't conduct that final reduction necessary to define its material a priori, the necessary content or essence of the law itself, defined in enactments.
And that leaves the stage wide open for the next step. We've established the method, we've established the category we need, so now we can ask the central question.
What is the essential content that law must possess to be coherent?
We have to apply that eidetic reduction to the noematic dimension of civil law itself.
Penetrating beyond all the technicalities, all the factual realities of different legal systems to unveil its universal necessary structure.
And this is the heart of our deep dive. The central contention here is that by performing this final reduction on the essence of civil law defined as enactments, the only universal content that remains is what we call human rights.
Yes.
And again, just to be crystal clear, these are not moral assertions. They're purely ontological descriptions.
That is absolutely the fundamental shift in perspective. We are not legislating. We are describing the conditions of possibility. If law exists as a coherent concept, these three material a priori laws must hold true.
They function as the conditions required for any enactment to even logically exist.
Exactly.
So let's detail the first of these three universal and necessary conditions, the foundation of the entire legal structure.
The first material a priori is this. 1. All civil laws come from and are aimed at rational and free beings.
The primary law.
It is. It rests on Reinach's finding that law stems from active acts, those acts that are motivated and arise from conscious decisions. If you remove rationality and freedom from the equation, you remove the possibility of social acts, and thus you remove the very possibility of law.
So any law, just by existing, presupposes the inherent dignity and capacity of the subject it governs.
Exactly. The moment a law is enacted, it implicitly confirms that the subjects it governs are capable of understanding it, deciding about it, and motivating their behavior in response to it.
If a state passes a law aimed at a society of ants or bees, as we noted earlier, that law is incoherent. It makes no sense.
It's nonsensical. And it applies equally if a law aimed at human beings attempts to treat them as mere objects or as purely instinctual deterministic entities without free will.
And this is where we see the first essential right appear. If law requires rationality and freedom to exist, then any enactment that fundamentally denies or attempts to extinguish that rationality or freedom
is immediately incoherent with the very essence of law itself.
It creates a legal paradox.
It does. I mean, think about laws that might target psychological states or intentions, which are sometimes called thought crimes.
Right.
While positive law might sometimes regulate things like planning or conspiracy, the material a priori limits the state from regulating purely internal acts. Why? because the law is grounded in the subject's rationality and freedom, and genuine freedom requires an internal, autonomous sphere of decision. A law forbidding a specific political thought, for example, damages the coherence of the legal system because it attempts to regulate the very core of the rational agent it relies upon for its own existence.
This first law is fundamental, but law also requires interaction between these beings. That brings us to the second necessary condition.
Yes, two. All civil laws arise from intersubjectivity between rational and free beings. As Reinach established with social acts, law requires at least two persons.
No law of one alone.
No law of one alone. The very concept of an enactment requires a source and an aim, an agreement, a dispute, or a regulation between two or more subjects.
This sounds straightforward, but its implications are vast. It dictates that even environmental law or laws governing global trade are, at their core, about managing the interactions between human agents.
Precisely. If we talk about animal rights or environmental protection, the law doesn't issue commands to the animals or the trees.
Of course not.
It regulates the free and external behavior of human agents in relation to those entities. The moment you remove the human interaction, the law ceases to function as civil law. If a person were the absolute last human being on Earth, all civil law would cease to exist, even if the written statutes remained on some server somewhere.
Okay, so the third material a priori law is about the legitimate scope of law. If the first two define who law is for and where it exists.
The third defines what it can target.
And what is that?
It's the three. All civil laws regulate only free and external behaviors. This sets the boundary of legal intrusion. Law is about regulating possible actions, acts that are motivated, free, and external. And there are two major exclusions here.
The first one being biological or physical inevitabilities.
Correct. Law cannot coherently regulate acts that are inexorable and cannot be motivated. You cannot legislate against aging, or against the necessity of breathing, or against the natural process of decomposition after death.
A law forbidding people from dying would be fundamentally incoherent.
Because the subject cannot decide otherwise. It's not a free act.
And the second exclusion is, I think, even more critical. It excludes purely internal, non-manifested acts.
Yes. Civil law cannot regulate internal mental decisions, deep-seated spiritual beliefs, or unmanifested feelings like sorrow or grief or happiness.
Let's use the example of forced conversion.
A perfect example. A positive law might mandate that all citizens must follow a specific religion. It can enforce external compliance, attending services, signing documents, wearing specific clothing.
But it cannot, by its very nature, force internal conviction or spiritual belief.
It's impossible. Therefore, a law demanding forced conversion, even if it's enacted and enforced successfully in the physical world, is ontologically incoherent with the essence of law. It's attempting to regulate something that is outside the domain of regulation.
It's an attempt to regulate the irrational.
And the law relies on the possibility of a free, motivated external response. Internal acts fall outside that scope. So these three necessary conditions, rational and free beings, intersubjectivity, and the regulation of free and external behaviors, these are the material idos of civil law.
They're universal, descriptive, and, let's emphasize this again, crucially, amoral.
Yes.
Why is it so important that they be amoral descriptions and not moral prescriptions?
Because the moment you introduce morality, justice, goodness, fairness, you introduce variability and subjectivity. You introduce debate. This phenomenological grounding seeks necessity. These three laws are merely descriptions of a necessary state of affairs, the coherent structure of law. They cannot be judged as just or unjust. They can only be judged as a correct or incorrect description of the essence of civil law.
And that descriptive logical foundation is precisely what makes them immune to cultural relativism or ideological capture.
That's the hope. That's the entire point.
This theory is incredibly elegant, but how does this amoral, descriptive essence interact with the chaotic reality of judges and legislators and citizens?
Right, the real world.
We need to analyze this interaction across three distinct spheres of analysis to see how it works.
Understanding these spheres is key. It prevents us from mixing up what is necessary with what is practical. So first, we have the ontological sphere.
The realm of being.
The realm of necessary being. The material a priori laws are the necessary grounding. Enactments depend on them to exist coherently. This relationship is necessary and objective, and it's independent of human will. It just is.
Okay, sphere one. What's second?
The epistemological sphere. This is the realm of knowledge. The a priori laws are tools for comprehension. They help the subject, the philosopher, the lawyer, the citizen, better understand the positive laws enacted around them.
So by knowing the essence, we can identify the universal elements hidden inside the contingent statute.
You can see the blueprint inside the building.
Okay. And finally, the practical sphere. This is the realm of decision and application, and this is where the necessity disappears.
It does. Exactly. In the messy world of policy and jurisprudence, the relationship between the a priori laws and the enactments is no longer automatic or necessary. Adopting these material a priori laws, human rights as a criterion for evaluation, is a social act.
A choice.
A choice. It requires a conscious, rational decision by the people, citizens, legislators, judges, to utilize this descriptive framework as a standard.
So human rights only gain practical force and become a limit on positive law if a society collectively and rationally decides to use the law's own essence against its contingent enactments.
That is the pivotal moment.
Yeah.
And once adopted, this framework acts as a limit and criterion. If an enactment is structurally incoherent or incompatible with the material a priori, it is judged invalid and must be abrogated.
And crucially, the judgment is based purely on logical coherence.
Not on moral indignation or political preference.
This framework also allows us to clearly distinguish between justifiable and unjustifiable legal deviations. Let's return to the hierarchy you mentioned earlier. The material a priori laws are superior to the formal a priori laws.
Yes, the human rights layer is foundational.
Let's use the classic example of the prodigal's promise to illustrate this.
Okay. The formal a priori law, as Reinach showed, states universally that a promise incurs a claim and an obligation. A legislator knows this ontological truth.
Yes.
But almost every legal system has positive laws that invalidate a promise made by a prodigal, a person who has been legally judged mentally incapable of managing their assets or decisions.
Then this positive law is a clear deviation from the formal a priori. It's saying this promise creates no obligation.
It is a direct contradiction. So why is this deviation justifiable?
It must be because it serves a higher necessity.
It does. It serves the protection of the material a priori. Specifically, it protects that first condition of possibility, the existence and integrity of the rational and free being. The state recognizes that for a legal subject to participate coherently in the system, their capacity, their rationality, and freedom must be protected.
So if they're allowed to bankrupt themselves through reckless promises, their future capacity to act as a free and rational subject is undermined.
And that undermines the very foundation of the law itself. So the lesson is clear. The material foundation of the law, the human subject, must prevail over the formal relational rules of the law.
Formal a priori laws can be ignored or deviated from, but only when it's necessary to protect the material a priori laws.
The hierarchy is undeniable. Human rights are the conditions of possibility. The formal relations only matter if they do not violate those fundamental conditions.
All right, let's now tackle an example of an unjustifiable deviation, one that violates the material a priori directly. The source uses the very difficult case of female genital mutilation, or FGM.
Right.
This is often defended as a cultural practice, which is rooted in intersubjectivity, and that's the second material a priori law.
This is a complex conflict, and it's often framed politically or morally, but here we're going to view it just through this logical lens. FGM is a tradition derived from group agreement, from intersubjectivity.
But the material a priori laws must all cohere with each other.
They must. FGM involves intentionally injuring or altering the genital organs for non-medical reasons, and it's typically performed on children who lack the capacity to consent.
And because it involves treating a rational and free being, a human person, as a mere object to be physically altered without their consent, it directly infringes the first material a priori law.
Absolutely. The act denies the humanity of the individual. It contradicts the most fundamental condition of law, that the subject of the law must be respected as a rational and free agent. The moment of practice, even one rooted in strong intersubjectivity like a cultural tradition, fundamentally denies the subject's status as a rational and free being. It is not merely immoral.
It is structurally incoherent with the definition of civil law.
Yes. The second material a priori, intersubjectivity, is limited by the first, the rational and free being.
So a state that legally mandates or even permits FGM is performing a legal act that contradicts the necessary essence that allows the state to pass laws in the first place.
That is the very definition of legal incoherence.
The law undermines itself.
It does. And this phenomenological foundation allows us to condemn the practice not by importing external moral values from another culture, but by asserting that the law, to be law, must be true to its own necessary nature.
This amoral grounding is powerful, but it's not without its challenges. The philosopher James Du Bois raised some important objections about the sufficiency of this approach, especially when you face complex legal questions where morality usually steps in.
Du Bois' first difficulty was skepticism. He was skeptical that these purely descriptive amoral laws could solve basic, everyday legal problems, especially in areas like property rights, which rely so heavily on positive legal constructs.
So how does the phenomenological grounding defend itself against that?
The defense is actually quite simple. We never claimed a priori laws were sufficient to solve all social problems. They describe the structure, the skeleton, but positive law, the enactments, must still fill in the gaps.
Provide the flesh and blood.
Exactly. As Reinach himself noted, the formal a priori describes the creation of original property. That's a necessary relation, but it doesn't detail how long a claim lasts, or how property is transferred, or what happens in cases of adverse possession.
So you need positive law for all of that.
Absolutely essential. You needed to provide this contingent content. Sometimes that positive law reinforces the a priori relations, and sometimes it deviates for practical convenience. The relationship is symbiotic, not exclusive.
Okay, that seems like a fair response. But Du Bois's second difficulty is perhaps the most dramatic. It really forces the theory to justify its hierarchy under extreme pressure. He uses the famous ethical dilemma of Paul and Peter.
A classic.
Peter is a wealthy landowner with more than enough food. Paul is starving to death. Can Paul take food from Peter without it being considered stealing?
This is where the amoral hierarchy truly proves its worth. If we use only the formal a priori of property, which states that Peter's original property creates an exclusive claim, then Paul taking the food is unequivocally stealing.
Case closed by the formal structure.
Right. It's a simple violation of a necessary relation. But the material a priori law must take precedence.
So how does that change the equation?
The material a priori reminds us that the primary condition of law's existence is the rational and free being. That's the first material law. If Paul dies of starvation, a rational and free being is removed from the legal structure. If the continued existence of property rights conflicts with the necessary condition of legal existence, the subject of the law, then the property right must be postponed or overridden.
So the existence of humankind, the subject of all law, is the highest necessary truth in the entire legal system.
It has to be. The material a priori dictates that the continuation of rational free subjects must prevail over the formal claims of property. A legal system that prioritized the protection of property over the sheer existence of its human subjects would be committing suicide through incoherence.
The very foundation of the law is the subject, not the object.
Precisely. Therefore, the right to existence, which is intrinsic to the first material a priori, justifies the overriding of the formal a priori of property in this emergency situation.
And this is a profound difference from traditional moral arguments for theft, which might rely on compassion or utility or something like that.
It is.
This argument relies purely on legal survival and logical consistency.
Exactly. It's a rational calculus about the structural integrity of the law itself. I mean, to take it to the extreme, if the whole of humankind were facing extinction, and the only possible remedy was an action that violated countless formal claims, say, violating patent laws to mass-produce a cure.
That violation would be legally justified.
And necessary. Any state decision that preferred patent rights over the existence of the human population would be making a fundamentally incoherent legal decision.
Finally, we have to tackle the persistent question, which was raised by commentators like Marta Albert. Isn't this just natural law theory, or I's naturalism dressed up in fancy Husserlian language?
It's a very fair question, and it's a critical distinction that has to be maintained. Natural law theory often holds that enactments are deduced from natural laws.
Implying a causal relationship.
A causal relationship, and also that the natural law has an inherent normative function. It commands what ought to be done. Natural law issues prescriptions for just behavior.
And the phenomenological approach rejects that causal prescriptive link.
Absolutely. The relationship here is one of grounding, not causation or deduction. A priori laws are purely descriptions of the necessary is the essence of law. They do not issue commands.
But surely the I's informs the ought.
Well, while the I's and the ought are not ontologically separate, the necessary structure does describe what a coherent ought would look like. They are fundamentally practically dissociated.
Meaning the description exists necessarily, but the decision to use it as a criterion is contingent. It's that social choice again.
It's the social choice. The practical ought, the decision to adopt human rights as a supreme criterion for evaluation, is a social act itself. It is a rational decision by free agents to maintain coherence. I's naturalism often assumes that because the law is natural, it might be followed.
Right.
Phenomenological a priori theory states that because the law is descriptive and necessary, we can follow it as a criterion if we rationally choose to maintain coherence.
So the a priori law stands beyond both positive law, because it's necessary.
And natural law, because it's descriptive and amoral.
It acts as the ontological and epistemological foundation.
It does. It provides the hidden structural elements that positive law relies upon, and it ensures that the legal discussion moves away from subjective moral preferences and toward objective necessary coherence.
This deep dive has taken us through a highly detailed, systematic philosophical exploration. Our core finding is that human rights, when you view them through the rigorous lens of phenomenology, are not moral or political declarations.
They're not just aspirations.
Right. They are the necessary, universal, and non-ideological essence, the material a priori of civil law itself. They are the structural conditions required for any legal enactment to be ontologically and logically coherent.
And this approach radically reframes the defense of rights. Their effectiveness hinges not on consensus about goodness or justice,
but on the rational, decisive choice by legal systems and by citizens to use this framework based purely on coherence and necessity as the non-negotiable limit for all contingent positive legislation.
We've really gone from the belief that human rights are just nice ideas to the understanding that they are, in fact, necessary truths.
To deny these core rights, the rationality and freedom of the subject, is not merely an oppressive act, it is fundamentally an act of legal self-sabotage, a contradiction in terms.
Which leaves us with this final, provocative thought for you to consider. If the continued existence and coherence of law itself depends entirely on the recognition and maintenance of human rationality and freedom as its essential a priori grounding, what profound and ongoing responsibility do rational and free beings have to maintain that legal coherence, especially when it demands the painful, rational invalidation of culturally accepted enactments or deeply rooted, long-standing traditions? The choice to make the necessary true is ultimately the highest social act.